You are looking at the exact moment Judge Caldwell lost patience. After the Witness 14 tape leaked this morning, the defense team didn't just lose the argument. They lost their freedom. Here is exactly what was on that tape. This isn't speculation. This isn't rumor. Federal marshals walked 3 defense attorneys out in handcuffs in the middle of a trial. When a sitting federal judge orders the arrest of officers of the court on live television, something catastrophic just happened. So what triggered this unprecedented courtroom explosion? At 7:47 a.m. Eastern this morning, an encrypted audio file appeared simultaneously on 4 major whistleblower platforms. The file was labeled W14 Privileged, Do Not Distribute. Within 90 minutes, it had been downloaded over 3 million times. By 9:15 a.m., the audio was playing on every major news network. That audio was Witness 14, the prosecution's star-protected witness, speaking in a recorded conversation that was never supposed to exist. This isn't just another courtroom drama. This is what happens when the most protected witness in a federal corruption case gets recorded by the very attorneys sworn to protect their clients' interests. And what they discussed on that tape goes far beyond legal strategy. Judge Caldwell's reaction tells you everything. He didn't call a recess. He didn't issue a warning. He signaled U.S. Marshals and had the entire defense table placed under arrest before the morning break. In 37 years on the federal bench, he has never done anything remotely like this. And I have the audio right here. I have the transcript. I have the court filings that dropped in the last 2 hours. Let me show you exactly what they're trying to bury. Here's what the Witness 14 tape actually reveals. The recording runs 11 minutes and 43 seconds. It captures a conversation between 3 individuals, now confirmed as lead defense attorney Marcus Webb, associate counsel Daniel Harriman, and a third voice prosecutors have identified as an intermediary working for the defendant's business associates. This is it. This is what everyone is talking about. The first bombshell drops at the 2:14 mark. Webb's voice, clear as day, states, "The witness needs to understand that cooperation has consequences, not legal consequences, personal ones. Make sure that message is received before Thursday." That was a direct reference to Witness 14's scheduled testimony. According to prosecutors who reviewed the full recording, Webb then discusses specific details from sealed grand jury materials, details that only someone with inside access could possess. At the 4:47 mark, the third voice responds, "The family situation has been made clear to him. Wife's employer, the kid's school enrollment. He understands what's at stake." The tape documents what appears to be explicit witness tampering, obstruction of justice, and the disclosure of protected grand jury materials. But here's the most damaging part. At the 8:22 mark, Harriman asks about payment arrangements. Webb responds, "The retainer covers this. It's been structured through the consulting LLC. Nothing traces back." Financial records subpoenaed this morning show wire transfers totaling $847,000 from an offshore entity directly connected to the defendant's former business partner. The timing of those transfers, January 3rd, 6th, and 12th of this year, matches the dates referenced in the recording. The FBI's lead forensic audio analyst, brought in within hours of the leak, has already authenticated the recording. Voice pattern analysis confirms Webb and Harriman with 99.2% certainty. The metadata indicates the recording was made on January 11th, 2026, just 5 days ago. But here's the kicker. The recording device wasn't planted by law enforcement. It was placed by someone inside the defense team's own circle. Court filings suggest a junior paralegal with access to Webb's office may have been cooperating with prosecutors for months. Former federal prosecutor Amanda Chen told MSNBC this afternoon that this represents one of the most brazen examples of witness intimidation I've ever seen documented. They discussed threatening a protected witness's family while apparently knowing they were being paid through hidden channels. The arrogance is staggering. The transcript continues with Webb providing specific instructions on how to approach Witness 14's brother-in-law, who works as a contractor for a company that does business with the defendant's associates. Make it clear the contract renewals depend on reasonable behavior from the whole family, Webb says at the 9:56 mark. And it gets worse. In the final 90 seconds, the three men discuss what to do if witness 14 doesn't respond to pressure. Harriman suggests making an example of a different witness in an unrelated case so word gets around. Webb's response? That's being handled separately. Different team. Legal analysts who reviewed these excerpts emphasize that this language suggests a systematic witness intimidation operation, not an isolated incident. If prosecutors can prove the different team reference points to additional criminal activity, this case could expand into a full RICO investigation. The defense table didn't just cross a line. According to every legal expert who has examined this evidence, they demolished it. Hit that subscribe button right now because this story is exploding by the hour. I'm going to be releasing updates as the court filings drop. And trust me, based on what I'm seeing, the next 72 hours are going to be unprecedented. Now you've heard what's on the tape, but here's how we got here, and it makes this even more damning. This trial began in late November 2025 as what appeared to be a straightforward federal corruption case. The defendant, real estate developer and political donor Victor Ashworth, faced charges of bribing local officials to secure zoning approvals and construction contracts worth hundreds of millions. Witness 14 was the linchpin of the prosecution's case. A former Ashworth Company executive who flipped after receiving a target letter, this witness possessed documentary evidence of cash payments, offshore accounts, and a network of shell companies used to funnel bribes. Tensions had been building for weeks. Aggressive defense motions to exclude key evidence, repeated attempts to unmask Witness 14's identity, what prosecutors described as a campaign of legal harassment against government witnesses. Everything changed on January 6th, when Judge Caldwell denied the defense's fourth motion to reveal Witness 14's identity. In his ruling, he noted increasingly concerning patterns in defense counsel's approach to protected witness issues. According to court documents filed this morning, the FBI had already opened a parallel investigation into the defense team on December 29th, based on a confidential informant's tip. That informant, the junior paralegal mentioned in the recording, had been wearing a wire for 3 weeks. This wasn't about aggressive lawyering. This was about a coordinated criminal conspiracy operating from inside the courtroom. On January 11th, the paralegal, whose identity remains sealed, recorded the conversation that leaked this morning. FBI agents reviewed the audio within hours, but held off on arrests to gather additional evidence. The leak changed everything. Sources indicate prosecutors had planned a controlled disclosure in sealed court proceedings later this week. Instead, someone, possibly connected to the same whistleblower networks used by the paralegal, pushed the recording into the public domain this morning. Marcus Webb, who founded his law firm 23 years ago and has represented some of the highest-profile white-collar defendants in the country, reportedly sat motionless as marshals approached. Daniel Harriman, a former federal prosecutor himself who switched to defense work in 2019, allegedly attempted to address Judge Caldwell before being told to remain silent. The third attorney arrested, junior associate Priya Nakamura, appeared visibly shaken. Her involvement in the recorded conspiracy remains unclear, though prosecutors indicated she, quote, possessed knowledge of the scheme and failed to report it as required by law. Smash that like button if this is making sense so far. Every like tells the algorithm this story matters, and it helps push this content to more people who deserve to know the truth. I read every single comment. Drop yours below. The bombshell moment came at 10:47 a.m., and everyone in that courtroom will remember it for the rest of their lives. Judge Caldwell had just received a sealed filing from prosecutors. Court observers describe him reviewing the document for approximately 90 seconds, his face growing visibly darker with each page. Then he looked up. "Marshals," he said. One word. The entire courtroom fell silent. 4 U.S. Marshals who had been stationed near the exits began moving toward the defense table. Webb rose to his feet, beginning to say something, reportedly starting with, "Your Honor, I must object." Judge Caldwell cut him off with a gavel strike so sharp that reporters in the gallery described it as sounding like a gunshot. "Mr. Webb, you will remain silent. You are being placed under arrest. Mr. Harriman, Ms. Nakamura, do not move, do not speak." Harriman's face reportedly drained of color. Nakamura began trembling visibly. Webb attempted once more to speak. Judge Caldwell's response became the moment everyone is now replaying. Counsel, I have reviewed the evidence of your criminal conspiracy to obstruct justice, tamper with a federal witness, and violate every oath you swore when you became an officer of this court. Your voice is no longer welcome in my courtroom. Marshals, proceed. Within 3 minutes, all three attorneys were in handcuffs. Victor Ashworth, the defendant they were supposed to be protecting, sat alone at the defense table as his entire legal team was walked out in custody. That's when it became clear this isn't just another courtroom scandal. This is the complete collapse of a legal defense through criminal self-destruction. Stay with me. What comes next is even bigger. But first, drop a comment below and tell me, did you see this coming? Have you been following this case? I want to hear from you. I respond to comments all day long. This isn't the first time defense attorneys have faced arrest for courtroom misconduct, but the scale and brazenness of this situation is virtually unprecedented. Think back to the 1990s mob lawyer prosecutions. Several attorneys representing organized crime figures were eventually convicted of acting as house counsel for criminal enterprises, essentially becoming participants in their clients' ongoing crimes rather than legitimate legal representatives. Those cases established that attorney-client privilege does not protect lawyers who become active co-conspirators. Then there was the 2008 case of prominent Texas defense attorney Stephen Crawford, disbarred and sentenced to 15 years after prosecutors proved he helped his client intimidate witnesses through coded messages during jail visits. That case, however, involved a single attorney acting individually. The key difference now? This appears to be a coordinated effort involving multiple attorneys operating with institutional support. The references on the tape to different teams and structured payments suggest something far more systematic than any previous case. More recently, in 2021, a defense attorney in Florida was removed from a murder trial after evidence emerged that she had contacted a witness's employer. She faced disbarment, not criminal prosecution, because the contact, while improper, didn't cross into explicit criminal threats. The web recording crosses that line repeatedly and explicitly. Former federal judge Richard Howell, who served on the Ninth Circuit for 19 years, told CNN this afternoon, "In my entire career, I never saw anything like this. Defense attorneys threatening witnesses' families, discussing payoff structures, talking about making examples. This isn't aggressive advocacy. This is organized crime wearing a suit." The pattern is clear. When officers of the court become criminals themselves, the consequences destroy not just careers, but entire cases. Now, however, the question becomes, what happens to Victor Ashworth's trial? His entire defense has been arrested. Every strategy, every motion, every cross-examination prepared by Webb's team is now presumptively tainted. The defendant didn't just lose his lawyers. He may have lost any chance at a fair trial. Legal experts are calling this morning's events extraordinary, unprecedented, and potentially case-defining for federal criminal procedure. Professor Rachel Morrison, who teaches legal ethics at Yale Law School, told the New York Times this afternoon that the implications extend far beyond this single case. What we're witnessing is the complete collapse of the attorney-client relationship's protective function. When your own lawyers are the criminals, every privilege, every protection, every strategic conversation becomes potential evidence against you. She added that Ashworth now faces an almost impossible legal situation. Any new attorney who takes this case inherits a poisoned record. How do you prepare a defense when you don't know what your predecessor shared with the prosecution's witnesses? Meanwhile, former U.S. Attorney Jonathan Blackwell, who prosecuted white-collar criminals in the Southern District of New York for 15 years, emphasized the recording's significance for potential RICO charges. The references to other teams handling other witnesses suggests this isn't isolated. If prosecutors can establish that Webb's firm operated as part of a broader witness tampering enterprise, everyone who touched those payments, partners, associates, staff, could face conspiracy charges. Criminal defense attorney and legal commentator Victoria Santos added the perspective that many in the defense bar are privately discussing. This is a nightmare for everyone who does this work legitimately. Webb was considered one of the best. 23 years, hundreds of cases, major victories. If he was doing this, What does that say about the pressure corrupting our profession? Santos noted that the fee structures described on the tape, consulting LLCs, offshore entities, structured retainers designed to obscure payments, suggest sophisticated awareness that the activities were criminal. These aren't mistakes. This isn't poor judgment in the heat of the moment. This is a system designed from the start to hide crimes. Even conservative legal commentator William Hardcastle, who has often criticized prosecutorial overreach, admitted on his podcast today that the evidence appears devastating. I've defended aggressive lawyering for 30 years. Aggressive isn't this. Threatening a witness's children's school enrollment isn't advocacy. Discussing how to make examples of other witnesses isn't zealous representation. If this tape is authentic, and the FBI says it is, then these men belong in prison alongside their client. The consensus among experts is nearly unanimous. The tape is authentic, the conduct is criminal, and the only remaining questions involve how far the conspiracy extends and how many additional people will face charges. Judge Caldwell's reaction, they agree, was entirely appropriate and arguably overdue. Do me a favor and slam that like button right now. It genuinely helps this video reach more people who need to see it. The algorithm responds to engagement, and every like pushes this story further. Help me get the word out. So what does this actually mean going forward? First, Victor Ashworth's trial is in complete chaos. Judge Caldwell declared a mistrial motion under advisement, but has not ruled. Ashworth's new legal representation, whoever agrees to take this catastrophe, will need weeks, possibly months, to review the case file. Every piece of evidence, every witness interview, every strategic decision made by Webb's team is now suspect. Prosecutors have already indicated they may seek to use the defense team's communications as evidence against Ashworth himself, arguing that attorney-client privilege was forfeited when the attorneys became co-conspirators. If Judge Caldwell agrees, Ashworth faces the unprecedented nightmare of his own lawyer's words being used to convict him. Second, the Department of Justice is expanding its investigation dramatically. Sources familiar with the matter told reporters this afternoon that a task force is being assembled to investigate what the recorded conversation called different teams. FBI agents executed search warrants at Webb's law firm offices in Manhattan at approximately 2:30 p.m. today. Additional warrants are reportedly pending for the firm's satellite offices in Washington, D.C., Miami, and Los Angeles. Every client Webb's firm has represented in the past 5 years may now face scrutiny regarding how their cases were handled. Third, the implications for witness protection protocols are enormous. Witness 14's identity, while still officially sealed, has been compromised. The threats discussed on the tape, involving family members, employment, and school enrollment, mean this witness and their extended family now require emergency protection. Sources indicate the U.S. Marshals Service has already initiated relocation procedures for multiple individuals connected to Witness 14. If this witness is permanently silenced through fear, harm, or disappearance, the prosecution's case against Ashworth collapses, regardless of what happens to the defense team. Fourth, the legal profession itself faces a reckoning. Bar associations in New York, New Jersey, and the District of Columbia have all announced emergency proceedings regarding Webb, Harriman, and Nakamura. Beyond disbarment, which now appears certain, civil liability looms. Every client Webb's firm represented may now have grounds to sue for malpractice. Insurance carriers are already reviewing exposure. Legal industry analysts estimate the firm will be bankrupt within months. The implications for public trust in the legal system are profound. When officers of the court become the criminals, when the people sworn to uphold justice conspire to obstruct it, faith in the entire system erodes. And hanging over everything is a simple, devastating question. How many other defense teams are doing exactly what Webb's team did? How many witnesses have been silenced before they could testify? How many cases have been corrupted by the very people sworn to pursue justice within ethical bounds? Nobody knows. After today, everyone is asking. And then the accused attorneys made it even worse. Within hours of their arrest, statements began emerging from representatives speaking on the defendant's behalf, and the approach they chose was telling. Marcus Webb's personal attorney, arriving at the federal detention facility, told reporters, "This is a politically motivated prosecution designed to interfere with Mr. Webb's effective representation of his client. The recording is being taken completely out of context, and we will vigorously contest its admissibility and authenticity." That claim collapsed almost immediately. When asked about the FBI's voice authentication and metadata analysis, Webb's attorney declined to comment and rushed into the building. Daniel Harriman's spokesperson released a written statement calling the situation a grave misunderstanding and claiming Harriman has always conducted himself with the highest ethical standards. The statement did not address any specific content from the recording. Here's the problem with these responses. The tape speaks for itself. When your voice is caught on an authenticated recording discussing threats to a witness's family, payment structures designed to hide your activities, and coordinated efforts to intimidate testimony, claiming context isn't a defense. It's an admission that you said what you said, and now you're desperate. Legal ethics professor Amanda Chen, who reviewed the transcripts, pointed out that the statements themselves may constitute additional problems. Claiming the recording is out of context implies the statements were made but meant something different. That's not how criminal defense of this evidence works. You either dispute authenticity or you explain conduct. Suggesting context while dodging specifics is the worst of both approaches. The defendant, Victor Ashworth, has remained silent. His family issued a brief statement expressing complete confidence in Victor's innocence and declining further comment while the legal situation clarifies. Court observers noted the irony. Ashworth's family is following proper legal crisis management while his own attorneys flailed publicly. Meanwhile, Webb's law firm attempted to distance itself from the arrested partners. A statement from the firm's management committee expressed shock and dismay and announced an immediate internal investigation. 3 named partners have already resigned, according to legal industry sources. Junior associates are reportedly fleeing to rival firms as quickly as they can. When your defense becomes worse than silence, you've already lost the narrative. But beyond the immediate legal firestorm, this is really about something much bigger. This is about whether the American justice system can survive when its own officers become the criminals. Defense attorneys exist to protect the accused. That protection is fundamental to constitutional liberty. Without zealous, ethical advocacy, the government's power becomes unchecked. Innocent people go to prison. Rights disappear. Justice dies. What Webb, Harriman, and apparently others did wasn't zealous advocacy. It was the weaponization of legal privilege to commit crimes while wearing the costume of constitutional protection. If this goes unpunished, if high-powered attorneys can threaten witnesses, structure hidden payments, and coordinate intimidation campaigns while hiding behind attorney-client privilege, then that privilege becomes a license for any crime. Every witness who ever considered cooperating with prosecutors just watched what can happen. Every victim who ever hoped the legal system might deliver justice just saw how easily it can be corrupted. This affects every American, regardless of political affiliation or feelings about this particular case. Because if we can't trust officers of the court to act within the law, the court itself means nothing. The robe, the gavel, the oath, they only matter if the people wearing and wielding them honor what they represent. Subscribe right now if you want continued coverage of this case. I'm going to be following every development, every hearing, every filing, every arrest. This story is far from over, and you'll want to be here when the next bombshell drops. Here's where things stand as of this afternoon. Marcus Webb, Daniel Harriman, and Priya Nakamura remain in federal custody awaiting arraignment. Bail hearings are scheduled for tomorrow morning in the same courthouse where they were arrested. Legal analysts expect the government to argue for detention, citing flight risk and the nature of the alleged crimes. Victor Ashworth's trial is suspended indefinitely. Judge Caldwell has scheduled a status conference for Friday, January 17th to address the mistrial motion and the question of new defense counsel. At least 4 prominent criminal defense attorneys have already publicly declined to take the case, citing conflicts and the, quote, toxic circumstances. The FBI is executing search warrants at Webb's law firm offices. Agents were seen carrying boxes of documents and computer equipment from the Manhattan office throughout the afternoon. Sources indicate the investigation now involves at least 18 agents and 3 separate federal prosecutorial teams. Witness 14 and associated family members are being relocated under emergency U.S. Marshals protection. Their testimony, originally scheduled for next week, will be rescheduled pending security assessments. The whistleblower who originally leaked the recording, not the paralegal who made it, remains unidentified. FBI officials told reporters they are not currently treating the leak itself as criminal, though that determination could change. State bar associations have initiated expedited disciplinary proceedings. Suspension orders are expected within days. Permanent disbarment will follow criminal disposition. Keep a close eye on Friday's status conference. Judge Caldwell's decisions regarding new counsel, evidence taint, and the prosecution's ability to use defense team communications will shape everything that follows. The next 72 hours will determine whether this case can continue at all or whether it collapses under the weight of its own corruption. The stakes have never been higher. The evidence has never been more damning. 3 defense attorneys are in custody. A protected witness is in hiding. A major corruption trial is in chaos. And the American legal system is confronting its own reflection. What happens next will define whether officers of the court answer to the same laws they manipulate. This isn't just another courtroom scandal. This is a test of whether justice applies to everyone, including the lawyers who claim to serve it. Hit subscribe and the notification bell so you never miss an update. I'm covering this story every single day until the final verdict drops. The reckoning is just beginning. I'll see you in the next one.